Okay, good afternoon, and thank you for the invitation. I would particularly like to acknowledge the friendship of the Foundation for Ecological Security, which made this analysis possible, and also to acknowledge my dear colleague Kanchi Kohli. The two of us together, along with Mr. Jagdish Rao of the FES, began this conversation on the particular judgment, though of course it was a common conversation, but it resulted in a series of work which spanned about 3 years, starting 2013 to 2016. So I have about 10 minutes to give you a little capsule of what we learned in this conversation and the learnings from that. For those of you who were not familiar, the judgment that I am talking about is the one that came before the division bench of the Supreme Court of India in 2011, when actually it came all the way up from the High Court decision of a division bench of the Punjab High Court and came in appeal. There's a long paper trail that led up to the bench at the Supreme Court, but unfortunately, because of paucity of time, I won't be able to walk you through. Suffice it to say that the essential facts of the case were that there was a village pond in a village in Patiala district in Punjab, and ironically, I mean, in North India, the word, Sanja comes from that, the lexicon and the language there in North India. So for me, it's particularly striking in North India that, this case comes from Punjab, where the Sanja is, and the lands there. I mean, irrespective of the number of the wide range of nomenclature that are there on those lands, and we were also referred to by the honorable judges in that case. But so this was about how a village pond had been filled in, constructed upon, encroached, and there were issues between the encroachers as well as the relationships between the Gram Panchayat, the district collector, and how all the way up it came to the Supreme Court, which opened up the case and said, well, this is of importance to beyond that particular case, and it needs to take on the shape of a public interest litigation. And the key points that the division bench kind of laid out there, a lot was said, but a digested view from our analysis, that it said clearly that it must push the state machinery to uphold the historic and traditional practices of commons within the villages. So they were very much talking about the physical commons and very much within the rural village landscape, and that those need to be urgently protected, and immediate corrective actions need to be taken against those encroachments, and no justifications for condoning illegal possession of village land and the regularization of construction only in exceptional cases where you either transfer land to the landless or you develop public utilities or schools for the underprivileged, or you have to give land and make land available to those from the scheduled castes and the scheduled tribes. But in terms of a clear to-do, in terms of a direction to state governments and all union territories, the state administration was asked to comply with directions of the Supreme Court to A, develop schemes, concrete schemes on what they would do about village commons, and secondly, to submit periodic compliance report. Now, initially it looked like that this case would be, as in mandamus, like the T.N. Godavarman case, that it would go on with an ongoing jurisdiction. But later, Chief Justice Honorable Altamas Kabir felt that there is enough in existing Panchayati Raj legislation which puts adequate responsibility on state governments and the relevant departments to oversee that the village commons are both kept out of encroachments and that they are positively restored. So there were clearly two directives. One was for a speedy eviction of all encroachments on village commons, and the other was to do something positive towards the restoration of the village commons. So like I said in the beginning of the conversation, it was towards the end of 2013 where we began the research, And this ran analogous to and was synergistic with some other research outputs that the FES itself was doing. There was an FES blog, which was called Claim for Commons Blogspot, so we drew from that and also fed into that. There was a listserv. It was very interesting that people from all across India joined the Commons Case listserv, where it wasn't so much about discussion, but sharing as we went along and picking up evidence from the implementation by the states. But that wasn't easy to get to, because in terms of the methodology, there were several challenges that we had. We did have to file a whole lot of right to information applications to several state government departments. Those got moved around to different departments. It was not always the same department in different states. And sometimes in particular departments, when people pursuing the case or against which when a notice is issued to a chief secretary, and it gets passed on to somebody else, and the person moves on, so there was no institutional or departmental history of that issue. So navigating all that, and then there were all the, with all due respect to my friends in the legal fraternity, I am a lawyer myself. It wasn't easy getting past a lot of the lawyers that were fighting the case for the different state governments. So despite that, we managed to get fair amount of responses from about 25 territories and states, so couldn't cover all 35 plus. But we brought about a series from 2014 to 2015, 6 issues of what we call the case for the commons, because as and when we got information from the right to information applications, we started updating the list as well as digesting what state governments were actually doing in response to the state. And that eventually led to a policy brief in terms of our recommendations on how do we move forward. But I guess a reminder which keeps coming up is, what if the case hadn't happened? And did we already have enough in our existing constitutional framework and laws that were already passed and rules at the local level, which would have at least egged the functionaries to move in a certain direction vis-a-vis the commons. Those of you familiar will know that the Directive Principles of State Policy make it constitutional duty to the state, on the state, to direct its policy towards, as Article 39B says, that the ownership and control of material resources of the community are so distributed as best to subserve the common good. Following the idea in 39C, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. And there are constitutional amendments, particularly 73rd Amendment, which has to be read with Schedule 11, which talks about the maintenance of community assets. And there are several provisions that we found that a lot of state governments had used in their existing Panchayat Acts, for instance, the Jharkhand Panchayati Raj Act, which clearly has provisions for freeing common lands from encroachment. So clearly, as in any law, it's not only about having the law, the letter of the law in black and white, or a judgment in black and white. It's about interpretation and implementation. And but a key issue that came about, because the judgment doesn't define the commons, or it doesn't add to the definition or understanding of what its interpretation of the commons were. The issue was, and that was a question that a lot of state departments were asking themselves and asking us when we approached them. Okay, so which commons do you want information on? Whether should we give you information on what we're doing about wastelands or grazing lands? And in terms of the different studies, ranging from JODA studies to that done by the National Sample Survey, way back in 1998, which was the first, in its 54th round, which was the first survey nationwide, accepting 3 areas, Ladakh, Kargil districts in J&K, Nagaland, and the 195 islands of Andaman and Nicobar Islands. Apart from those, this is what we had on record in terms of which commons are we talking about? Where are those commons? So clearly, one of the policy recommendations we also made that we do need a new additional updated survey on the common lands in India. But what were the key responses from the states? How were they responding to the directive of the Supreme Court? As I already mentioned, there were existing Panchayat acts that many of the state governments were using. And then there were instances where, as in Mizoram, Himachal Pradesh, and Andhra Pradesh, Telangana hadn't been formed then. Those were early days of 2014 when we were looking at this. But in Mizoram, there was a Mizoram Prevention of Government Land Encroachment Act in 2012 that was passed as a direct result of this. And the Act itself introduced a new definition, a set of definitions defining public land, public space, and community land, which is also defined in the Rural Land Use Plan for the Government of Mizoram's new land use policy, the NLUP. Likewise, Himachal attempted to amend the Himachal Pradesh Village Common Lands Vesting and Utilization Act of 1974. And in Andhra Pradesh, interestingly, the government of Andhra Pradesh, through its Panchayat Raj and Rural Development departments, issued a set of executive rules, one that is particularly talked about in this context and was even filed on record in affidavit by the state government before the Supreme Court of India, was the Andhra Pradesh Gram Panchayat Protection of Property Rules 2011. And then there were new orders, policies, and programs that certain state governments and relevant departments, also nudged along by groups like FES and other local activists, to have specific policies to be drafted on the issue of the commons. The value of the order, apart from just looking at the actual nuts and bolts of the legal process and the judicial process that followed, is really precedent setting, because there have been other cases that have come before other high courts, as in Orissa, where this decision has been used in precedent. There are a lot of people's movements that have been able to use this judgment in a lot of the work and lobbying and advocacy work that they do for the restoration of the commons in their own workspace. But what are the challenges that still remain despite? One is, clearly there is a definitional diversity that emerged from the different submissions made by the different state governments. Also, sometimes government lands were used, the understanding and categorization of government lands were used as if they were common lands and vice versa. Also, land-centric administrative approach. It was very, very centered around the land institutional structure, the land departments. Often there are issues of conflict even between jurisdiction between the Gram Panchayat, the Panchayati Raj department, as well as the revenue departments, but all very, very land-centered. So what I'm trying to suggest is there were other departments like the water department, the environment department of the states, which ought to also be part of this conversation of the implementation of the commons. But they were clearly there was no evidence at all that in any of the states from where we were able to gather information on the implementation of the judgment, that they were involved in any way. And on the ground realities, like the previous speakers have mentioned, there are always contested claims of ownership and also several challenges on the ground in real time which communities are facing to access the commons, even if the state is able to physically restore them, ecologically bring them back, breathe life into them, resurrect them. There are real-time issues about communities being able to legally access those restored or resurrected commons. And of course, there is an implementation challenge, as I said, about following through some of these orders that, in all good intentions, the state officials may have issued. And of course, another issue of devolution of powers to local bodies to maintain and keep those commons alive. But I think what a lot of the presentations point to is really what is the political economy, what is the kinds of demands that are being placed on the commons. And here I'm taking the liberty to go a step beyond what perhaps the organizers wanted from this particular presentation, is to see what are the demands and where there is the judgment and it can be used. There are certain areas in which it adds value. But given that there is the new needs and the new demands of the economy, how do you reconcile that? And can we, and going beyond this judgment, pick the principles of what it's upholding rather than what it's saying in the physical context of land and water commons. And I would like to extend the idea particularly to two areas that I work particularly closely on. One is intellectual property. And how do you talk about the intellectual commons given the kind of pervasive intellectual property rights and the abuse of intellectual property rights in the knowledge arena? So I think we need to pick up learnings from here that can be used in other sectors. Also in seeds, in the area of seeds, where extreme capitalism, extreme privatization, extreme commodification is actually alienating communities from their own seed systems. So how are groups that are imbibing from judgments and principles of the commons resurrecting their local seed system? And one idea in which they do that is through the open source seed system. I work with an Indian alliance of local seed savers, where we're trying to revive some of the lost food cultures as well as agricultural practices and traditional seeds. And that's where we're talking about it as a shared commons, keeping it outside of intellectual property regimes. Finally, since this judgment came from a division bench, from a court, from the judiciary, something to be said about the emerging architecture of dispute settlement. And at the one hand, when we started this conversation and we started looking at the judgment very closely, and we looked at dispute settlement venues or local fora, apart from the writ petition option within a high court, which is not very easy for the commoners to access, we looked at the the Gram Panchayat, the Gram Nyayalayas, which was act which came about in 2008, which is still an act, but how far local courts and village courts are made available and accessible to contest claims on the commons is an issue. But at the other end of the spectrum, we have international private arbitration suits that investors can now file against governments, which is unprecedented in international law, under the new generation bilateral investment treaties that we are negotiating. And early this year, the Secretary of Mines acknowledged that they received at the Central Ministry of Mining, that they received an arbitration claim that has been slapped by an Emirati investor when the access of the investor to the mines in the Schedule 6 areas of Visakhapatnam agency were cancelled. And so there's been an arbitration claim to the tune of $44.71 million that have been slapped against the government of India. So you have these private arbitration suits coming in, which is for contested use of land there. And there, at the other end of the spectrum, you have the local, the common, and the commoners. So the struggle continues. Thank you. I'll stop here.